Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 18th to 22nd, and today is April 25th, 2016. A swap execution facility sued multiple interest rate swap dealers and other entities claiming they colluded to prevent its success. In addition, 6 federal agencies proposed compensation rules that might result in more of the largest financial institutions' senior officers, including potentially chief compliance and legal officers, and substantial risk takers' incentive bonuses being subject to deferral for up to 4 years, as well as previously paid bonuses being subject to clawback for up to 7 years. There was virtually nothing that happened in the world last week that materially impacted exchange-traded derivatives, but there was still some interesting stuff out there, so let's get started. The Terra Exchange, a swaps execution facility registered with the Commodity Futures Trading Commission and related entities, brought a lawsuit in federal court in New York against multiple interest rate swap dealers and some of their affiliates, an enter-dealer broker of interest rate swaps, and an electronic trading facility for interest rate swaps that also operates a swap execution facility. Terra Exchange alleged that the defendants conspired to undermine it and other interest rate swap exchanges by, among other things, inhibiting customers of the interest rate swap dealers' affiliated futures commission merchants from clearing transactions executed on Terra Exchange and certain other interest rate swap exchanges. They did this, said plaintiffs, because the dealers objected to Terra Exchange's all-to-all central limit order book execution platform that might bypass the dealers. As a result of the defendants' actions, claimed Terra Exchange, it sustained substantial lost profits. Terra Exchange said that defendants' actions are a violation of federal and New York State antitrust laws, as well as of various common law prohibitions. Plaintiffs did not allege any violation by defendants of any law expressly governing swap execution facilities or exchange-traded swaps, or any rule of the CFTC. Terra Exchange seeks treble damages for defendants' actions and a permanent injunction against defendants continuing their allegedly unlawful conduct. This complaint is very similar to a complaint filed in December 2015 by the Public School Teachers Pension and Retirement Fund of Chicago. Their plaintiff, in a purported class action case, sued 12 swap dealers and, in some cases, certain of their affiliates, alleging they conspired to prevent interest rate swaps from being traded on exchanges. 6 federal agencies proposed bonus payment deferral and clawback arrangements for certain large financial institutions and certain of their most senior officers, including, potentially, chief compliance and legal officers, as well as employees who expose their firms to large risk if they receive incentive-based compensation. In general, the compensation rules would apply only to covered financial institutions that maintain consolidated access in excess of $1 billion US, while the most onerous requirements would apply solely to covered firms with consolidated access in excess of $250 billion US. Impacted institutions could include certain banks, broker-dealers, but apparently not future commission merchants, credit unions, and investment advisors. So far, only the National Credit Union Administration has formally published its proposed rules, although the other federal agency rules are expected to be similar. Under the proposed rules issued by the National Credit Union, the biggest firms will be required to defer a substantial portion of their incentive-based bonuses of senior executives, up to 60%, and significant risk takers, up to 50%, for 4 years, and require the clawback of previously paid bonuses up to 7 years if it is later determined that a senior executive or significant risk taker engaged in misconduct that, quote, resulted in significant financial or reputational harm to the covered institution, fraud, or intentional misrepresentation of information used to determine the covered person's incentive-based compensation, end of quote. The Securities and Exchange Commission expressed its intent to file a friend of the court brief in a lawsuit filed by Scottsdale Capital Advisors Corporation and certain of its senior offices against the Financial Industry Regulatory Association a few weeks ago, in which Scottsdale challenged FINRA's authority to bring a disciplinary action against the plaintiffs, alleging violations grounded in the Securities Act of 1933. Plaintiffs had contended that FINRA had no authority to prosecute claims under the Securities Act because its disciplinary authority is limited to matters that might constitute a violation of the Exchange Act of 1934, a provision of U.S. law that established the SEC, authorizes national securities associations such as FINRA, and generally governs the secondary trading of securities, financial markets, and their participants, including broker-dealers. The Securities Act, on the other hand, generally addresses solely the issuance of securities, including imposing registration and disclosure requirements. Among other things, the SEC indicated it will argue that plaintiffs' federal law case is untimely, and then plaintiffs must first pursue their administrative remedies before asserting any challenges in a federal court. And finally, the Financial Stability Oversight Council issued an update on asset management products and activities that it claimed might pose threats to national financial stability, including liquidity, redemption, and leverage risks. Although the FSOC report noted certain recent initiatives of the Securities and Exchange Commission to enhance liquidity risk management and disclosure at registered funds, and to limit the amount of leverage that registered investment companies might obtain through the use of derivatives, FSOC still issued its own recommendations of steps that might be taken to reduce relevant risks. Frankly, no new ground was broken. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles in the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Until next week, have a great week, and ciao.